Hello and welcome. My name is Tamanna Begum and I'm a housing and property disputes paralegal at Anthony Gold Solicitors. Today I am joined by my colleague Nikki Basin, who is a solicitor in the housing and property disputes team. Thank you very much for joining me today, Nikki.
Hello everyone.
As you know, this is going to be a short Q&A on rent repayment orders, or RROs, and we will try and answer a few questions which landlords and letting agents or even advisors may have in relation to rent repayment orders. Without further ado, we will get into our first question. The first question, Nikki, is what is a rent repayment order and who can make the order?
Great, thank you, Tamanna. So a rent repayment order is an order made by a tribunal. The first tier tribunal property chamber makes the order for the repayment of an amount of rent or housing benefit or universal credit which has been paid in respect of the rent. Rent repayment orders can be thought of as a type of fine imposed on landlords for breaking their legal requirements, but they are different from other types of fines because tenants can apply for them themselves, and if they are successful, they get to keep the money.
Sure, and so who can make the application to the tribunal and for what reasons can the application be brought?
So a tenant or a local authority can make an application for a rent repayment order pursuant to Section 41 of the Housing and Planning Act 2016. The table of offences for which a rent repayment order application may be made are set out in Section 40, subsection 3 of the Housing and Planning Act 2016. These offences include using violence to secure entry, unlawful eviction or harassment of residential occupiers, failure to comply with an improvement notice or a prohibition order, being in control or management of an unlicensed house in multiple occupation, being in control or management of an unlicensed house. This is where the landlord should but does not have a selective license under Part 3 of the Housing Act 2004, and also a breach of a banning order, but these offences are set out in the table under Section 40, subsection 3 of the Housing and Planning Act 2016.
Thank you, Nikki, that's very helpful. So what exactly are the time limits for making the application for both local authorities and private tenants?
So a tenant has 12 months to make an application. They can make an application for a rent repayment order only if the offence relates to housing that at the time of the offence was let to the tenant, and that offence committed no more than 12 months before the date on which the application is made. For local authorities, slightly different requirements apply because it will be relevant whether or not the local authority has complied with Section 42 of Housing and Planning Act 2016. Most rent repayment order applications are about failing to hold a license, and this kind of offence was committed not on one particular day, but over a range of dates, perhaps months and even years. So time starts to run when the offence stops being committed. So in practice, what this means is that tenants need to make the application within 12 months of whichever event comes sooner, moving out or the landlord applying for a licence or a temporary exemption notice, or the landlord no longer requiring a licence for some other reason.
Sure. So what exactly are the requirements under Section 42 of the Housing and Planning Act, and what time limits apply to local authorities?
So before a local authority can apply for a rent repayment order, it must give the landlord notice of its intention to commence proceedings. The notice will require the local authority to inform the landlord on why the authority is proposing to apply for a rent repayment order, and explain why and state the amount it seeks to recover, and invite the landlord to make representations. Any representations made during this time must be considered. and the local authority will need to wait for the notice period to end before applying to the tribunal. A notice of intended proceedings cannot be given after the end of 12 months, beginning with the day on which the landlord committed the offence to which it relates.
So does the applicant need to be the landlord's tenant?
The applicant can be either the tenant or the local authority. However, tenants will not receive any rent from a local authority application. Those applications are purely about forcing the landlord to pay back rent, which was paid through benefits. In those cases, the money is paid to the local authority.
I see. So what happens when a landlord receives a notice of intended proceedings? What should they do, and how long will the process take in the tribunal?
So the landlord should check that the notice complies with the requirements under Section 42 of the Housing and Planning Act 2016. They should consider putting in representations within 28-day period. We would always recommend that landlords take legal advice at this stage before putting in any representations, which may make the situation worse.
Sure. If a landlord has not licensed a property but has not been convicted of an offence, can a tenant or a local authority then still apply for a rent repayment order in the tribunal?
Yes, so under the Housing and Planning Act 2016, this is possible. The first tier tribunal must be satisfied beyond reasonable doubt that the offence has been committed. There is no need for a landlord to be convicted before an order for a rent repayment order is made.
Okay. So, Nikki, I have received a question from an agent regarding rent repayment orders. They're looking to see whether an order can be made against themselves or their company.
No, so a rent repayment order claim can only be made against the landlord.
Thank you. So what factors do the tribunals take into account when making the order?
So when deciding the amount of a rent repayment order, the law requires the tribunal to establish the relevant period. Then the maximum award will be the full rent which was paid during that period. The tribunal then must also take into account three factors. And these are the conduct of the landlord and the tenant, financial circumstances of the landlord, and whether the landlord has been convicted of an offence to which this chapter applies.
And how much rent can be awarded to the tenant for each offence in making the determination? What does the tribunal take into account? Can they take into account any mitigating factors?
So the starting point will be full rent for the relevant period. The relevant period can be up to 12 months. For example, a landlord failed to hold a HMO for, say, 6 months, the relevant period would only be 6 months. For other offences, such as lawful eviction, the relevant period is always 12 months. The upper tribunal, in a recent case known as Basin and Stewart, held that a rent repayment order should not be limited to the landlord's profit, and it would not be appropriate to deduct the rent, everything the landlord has spent on the property during the relevant period. So anything spent on maintaining or enhancing their own property would be unfair to deduct. In situations where the landlord does pay for utilities, there is a case for a deduction to be taken into account there. Now, the tribunal's usual approach has been to reach a final figure by awarding a percentage of the rent after deductions to the tenants, so a percentage of the net rent. If the tribunal is very unimpressed with the landlord, they might award the full 100%. If they sympathise more with the landlord, the percentage might be 50% of the net rent.
I see. I have a second question from a landlord. They've asked, I'm a landlord and I have to make mortgage payments every month, and I have incurred maintenance costs while the tenants occupied the property. Can that be set off from any award?
No, so this is exactly the issue that the upper tribunal dealt with in Basin and Stewart. the upper tribunal said that it would be unfair to deduct anything the landlord spent on maintaining and enhancing their own property. So any mortgage payments the landlord has to pay would not be deductible.
Oh, thank you very much, Nikki. That brings us to the end of our questions. Thank you to everyone who has listened in today. If you want to sign up to our quarterly property newsletter, you can do so by emailing in to marketing@anthonygold.co.uk. Thank you.
Great, thank you.